ERISA. If your disability claim will be made under your employer's group disability insurance policy, it's likely governed by ERISA, which stands for the Employee Retirement Income Security Act. This is a federal law enacted in 1973. Under ERISA, you have the right to file a suit in federal court if your disability insurance company denies your claim for benefits. Unfortunately, unlike almost any other legal situation, under ERISA, the disability insurance company walks into federal court with an advantage. The ERISA disability insurance system and your disability policy has been shaped by insurance company lobbyists in Washington, D.C. It's biased and rigged against disabled people such as yourself. Some disability policies simply are not worth the cost of the paper on which they're printed. The vast majority of these bad policies were sold by disability insurance companies who took advantage of your employer. Incredibly, I've seen that employers and their human resources personnel often have no idea how bad their own disability policies really are. Remember, the law doesn't require employers provide you with disability coverage, nor does it require that the disability plan have any specific terms. There is no federal or state oversight of disability insurance policies. While state departments of insurance can regulate the terms of individual or so-called private policies, there's no corresponding state regulation of employer-sponsored policies. Read your disability policy right now. If you don't have a copy, order one through your employer or your broker. If you see any of the following things in your policy, you should be worried. The insurance company has the discretion to determine your benefits. You only get paid benefits if you can't perform each and every important duty of your job. The duties of your job are determined by the insurance company's use of the Dictionary of Occupational Titles and not based on how you've performed your job for your employer. Your benefits are limited to 24 months if your disability is caused or contributed to in any fashion by mental illness, depression, or anxiety. Your benefits aren't payable or can be limited if your illness is fibromyalgia, chronic fatigue, chronic pain, or an illness in which the symptoms are self-reported and not verifiable by any diagnostic study. Your benefits will be terminated if the insurance company says you can work part-time in any job, regardless of your ability to find such a job. If you're disabled or have applied for and been denied benefits, any of the clauses mentioned will greatly increase your difficulty in getting the disability benefits you're rightfully owed. None of these provisions are required by law. Nevertheless, even though insurance companies aren't in any way obligated to do so, many sneak these nasty little clauses into policies. Plain and simple, this is a typical example of how insurance companies refuse to pay you in order to save themselves millions of dollars. Amazingly, the same insurance companies will routinely refuse to pay benefits based on the sneaky policy clauses, telling their insured, "We're sorry your employer bought such a lousy policy, but we can't pay your benefits."